Okay, my phone went dead. I'm losing memory, so I'm going to try to knock this out quick. In answering a guilty plea to a lesser included offense in an indictment charging 2 or more offenses, both court and prosecutor must consent. In answering a guilty plea to a lesser included offense, both the court and the prosecutor must consent. A subpoena other than certain child support subpoenas is generally served like a summons, in the same manner as a summons. The minimum notice required to be given to an attorney to appear on the arraignment of his client on an indictment is, this is 210.10-1, 2 days. We're just knocking these out. The minimum notice to give the attorney to appear on the arraignment of his client on an indictment is 2 days. For venue purposes, an executor, administrator, or testamentary guardian shall be deemed a resident of the place where he was appointed, as well as his residence. That's CPLR 503. Provides that for purpose of determining venue, an executor, administrator, or testamentary guardian shall be deemed a resident of the county in which he resides in and the county of his appointment. Okay? And 503 is venue based on residence. Interesting. Okay, a subpoena duces, some people say tecum, I'm saying tecum. That's how I like to say it. If you have a problem with that, I don't know what to tell you. 2305B, so a subpoena, and 23 is subpoenas, FYI. Article 23. A subpoena duces tecum may be joined with a subpoena to testify for a trial, hearing, or examination. Because think about it, duces tecum is about producing books and documents, right? You're producing the books and documents, but maybe you want someone to talk about what they're producing. So then, well, you're going to pair that shit up with a subpoena to testify at a trial, hearing, or examination. That kind of makes sense, that it would be joined like that. Okay, good. Next. CPL 210.30, a motion to dismiss an indictment on the ground that the evidence presented to the grand jury was legally insufficient to establish the offense charged, must be accompanied or preceded by a motion to inspect the grand jury minutes. So, a motion to dismiss on indictment on the ground that the evidence presented to the grand jury, okay, that's why they need the minutes. They're going to look through that shit. So you're going to do the motion for the minutes, the motion to inspect the grand jury minutes is going to be done either prior to entering the motion to dismiss, preceding it, or with the motion to dismiss. You got the motion to dismiss, and then you got the motion requesting inspection of the grand jury minutes. Right, and that's because this motion to dismiss is an indictment is on the grounds that the evidence presented to the grand jury was legally insufficient to establish the offense that was charged. Good. Next. Okay, so these are more juicier, so I'm gonna slow down a little bit so we could get into it. A motion. This is 3030. 3030 is all about speedy trial. Woohoo! A motion to dismiss must be granted if people are not ready for trial within the following periods after filing of an accusatory instrument. So, motion to dismiss has to be granted, okay? Because the following periods after filing the accusatory instrument. So I believe it's 6 months, 90, 60, 6 months, 90, 60, 30. 6 months, 90, 60, 30. Is that right? I believe so. I got it right. Hot diggity dog. All right. So let's talk about the offenses that it's relative to. But remember, you're going to remember 6 months, 90, 60, 30. 6 months, 90, 60, 30. Motion to dismiss granted because you're holding this guy and you haven't started the trial. Hello. Okay. So felony is 6 months. So if you haven't started the trial for a case involving the felony by 6 months, that motion to dismiss must be granted. Misdemeanor over 3 months, that's an A misdemeanor, 90 days. Misdemeanor up to 3 months, 60 days, that's a B misdemeanor. Petty offense, 30 days. Next. Okay, 30-30. Speedy trial does not apply to murder in the first degree, manslaughter. Is it first degree? I believe. Sorry. Murder in the first and second degree, manslaughter in the first and second degree, criminally negligent homicide, and aggravated murder relating to a police officer. So murder in the first or second degree, correct. Manslaughter in the first or second degree, correct. Criminally negligent homicide, correct. And aggravated murder, and then murder of a police officer. 30-30. So you can't do no speedy trial for these bastards. There's going to be no speedy trial. They're going to go as slow as they need to go because these are serious, serious charges. Murder in the first or second degree, manslaughter in the first or second. This is the shit that you see on court TV with Vinnie Politan. Okay. Criminally negligent homicide, aggravated murder, murder of a police officer. Good. Next. 30-30. Now we're doing CPL 190.25-1. An affirmative action of the grand jury, such as an indictment, requires the concurrence of at least 12 grand jurors, 12 members of the grand jury. Remember, the grand jury is made up to 16 to 23 members. 16 have to be present, but the ones that have to concur are 12. That is for an affirmative, a yes action of the grand jury. You need a concurrence of 12 of those grand jurors, okay? And I just brought up 1623 because you should know that. Straight up. Let's go. Okay, we're back to CPL 30-30, where defendant has been committed to the custody of the sheriff. He must be released on bail or his own recognizance where the people are not ready for trial within the following days after commencement of defendant's commitment to custody of the sheriff. So the sheriff is holding on to the defendant, okay? But he must be released on bail or on his own recognizance where the people, once again, they're not ready for trial and the sheriff has him. The other one was motion to grants a motion to dismiss because he was being held. This specific one is related to the sheriff. So the other one, motion to dismiss, was 6 months, 90, 60, 30. This one we're going to leave out. Shit. Hold on. We're going to leave out, I think, my brain is fried. I think we're leaving out 30. We're leaving out 30. We're going to go for that. This is like gambling. I've never even been to a casino, but all right. We're leaving out 30. One of them has to be left out because felony is going to be 90 days. Misdemeanor A, that's over 3 months, is going to be, oh my God, is going to be 60 days. Misdemeanor, B misdemeanor, which is under 30 days, is going to be 15 days. And then petty offense is going to be 5. Let's check. Ah! I fucked up. It's supposed to be leave out 60 days, not 30 days. Fuck. Scratch that. It's 90, 30, 15, 5. I just wanted to test myself, and it's a good thing that I did. So now that I fucked up, you're not going to fuck up, right? Good. Neither one of us are going to fuck up on this one. 90, 30, 15, 5. No 60 for the sheriff. No 60 for the sheriff. Because he's already retired. 90 days for a felony. 30 days for an A misdemeanor, which is over 3 months. 15 days for a B misdemeanor, which is over 15 days, and petty offense is 5 days. 90, 30, 15, 5. 90, 30, 15, 5. No 60. No 60 for the sheriff. No 60 for the sheriff. Okay. I'm really losing it. A criminal prosecution must be commenced. This is 3010, CPL 3010. Accusatory instrument filed within Class A felony is going to be any time. Any other felony is going to be 5 years. Misdemeanor is going to be 2 years, and petty offense will be 1 year. And I'm certain of this one. I'm certain. Bam. Okay? So Class A felony anytime. Any other felony within 5 years of commission. I should put that stuff in there. Misdemeanor within 24. I can always say that 2 years because my Y's look like a 4 and it throws me off. Within 2 years of commission. Petty offense within 1 year after commission. So remember those, they're all of commission except for petty offenses after commission, within 1 year after commission. Okay, good. Okay, this is CPLR 312-A. If a defendant properly acknowledges receipt of a mailed summons and complaint, he must serve an answer within 30 days after the signed acknowledgement was mailed. I know, I forgot about you visual guys out there. Okay, 30 days. Oh shit, I got it wrong. Oh my God, I'm fucking up so bad. Don't feel bad if you can't get it. Look at me. Oh. You know why? I'm not stopping to think about it. I'm just like drilling these out. Shit. I'm sorry guys, it was 20 days. I don't know if I should edit this because you know what? If I make a mistake, I'm going to remember this shit. I don't know if I'm going to edit this out. So I'm going to say it correctly this time. If a defendant properly acknowledges receipt of a mailed summons and complaint, he must serve an answer within 20 days after the signed acknowledgement was mailed. 20 days. This is about serving the answer. This isn't about completion of personal service. That's where I effed up. Completion of personal service is going to be 30 days. And serving of the answer is going to be within 20 days. And this is if a defendant properly acknowledges receipt of a mailed summons. He's acknowledging. He gets the summons. He signs the acknowledgement and then he answers it. He's going to answer. Acknowledges receipt. So his answer is basically acknowledging, right? Properly acknowledges receipt of a mail summons and complaint, he must serve an answer. Okay, it doesn't say anything like that, but his answer is basically, you know, aside from the acknowledgement, he's serving an answer within 20 days after the signed acknowledgement of receipt. CPLR 312A states that where a summons is served with complaint, the defendant must serve an answer within 20 days after the date the signed acknowledgement of receipt is mailed or delivered to the sender. All right, let's go to the next one. How much? Well, I already know this one because I fucked that one up, but all right. This is not something funny to be laughing at, all right? Get it together. In order to complete personal service by mail, this is the thing about completing personal service by mail, okay? So the defendant, an authorized employee of the defendant, defendant's attorney, or an employee of defendant's attorney must complete the acknowledgement of receipt and mail or deliver it to the plaintiff within 30 days of its receipt. This is completing personal service by mail. I remember I read something to you on this before. It's 312. Like, I feel like we've gone down this road before, I'm pretty sure. Because remember, if it's by mail, you're not literally handing it to someone, so you get an extra 10 days. I believe that's what it was. Look that up. Look that up. I have another video about that, more in detail. But this is in order to complete personal service by mail. The defendant, an authorized employee of the defendant's attorney, or an employee of the defendant's attorney must complete the acknowledgement of receipt and mail or deliver it to the plaintiff within 30 days of its receipt. And there it is. I got it right. Okay. I'm going to leave it. I'm going to leave the mistakes on this video, because you know what? You need to be testing yourself and be like, she ain't right. And also, I got to tell myself, yo, remember that. You know, you don't want that to be your Achilles heel on the test. We got to be the Terminators. Let's go. Thank you for watching. Toodles.